be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My lords are more guided, but when Justice Rima was giving the clarification, I never heard him clarify whether the Kirogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kirogoya. Because of course, if there is no integration, your lordship, then there is a rat that is smelling.
Let me answer you. You said that records speak for themselves. And for record, matters which came from Kirogoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kirogoya was already consolidated. Those proceedings which took place in Kirogoya consolidated these 2 files. So let that not be an issue here. On the directions issues on 11th by Judge Richard Mwongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the party's response to the amended petition and petition E013 of 2024 may be filed in Kirogoya under the Kirogoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kirogoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Kirogoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kirogoya is this. Going by the orders which were issued by Kirogoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kirogoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we may now raise the issues that we want to raise, particularly arising from the issues in Kirogoya. And I do not
know. Then proceed and take forum on it. They were consolidated, so we don't take further forum on this matter.
The Attorney General, I don't know, I had indicated to the court earlier, I need to raise some clarifications.
Section 7 of the Attorney General's Act.
You had read your subject to speak. It doesn't override my right to represent my clients.
I will repeat it.
Can she then say her piece, I say mine?
Which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that.
Yes.
The only matters before this court are the matters which had ex parte orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders. We have E15.
E15 has
Conservatory orders, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservatory orders.
I hope I can then be heard without further interferences. My Lord,
Which is the amount of Mr.
My Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15.
Kerugoya 15, yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on record. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice Will, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitutions. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may
I think I have a right to raise those issues. You will have a right to respond.
Just give fellow Mungai time to...
Mungai, Boigai.
I just wanted for good order,
Okay,
my Lord.
is that a clarification, Mungai?
Well, I am Mungai. I believe he will speak in response as soon as I'm done.
Proceed.
Let me finish.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Maraja, Professor Boigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and as the court, I should be heard in silence. He will respond. And I dedicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated, we could not put it earlier in an application. So if I may proceed, my lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lord, under the former constitution, under the former constitution, we used to have a practice in which we had an officiary, a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
You apply that we discharge the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Chief Justice, Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My lord, I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue we speak for the 190 and with a clear conscience. 2 things. My lord, the first thing would be this, that if this matter is going to be conducted, like today, on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be had, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state? And it used to happen those days before we had a new constitution. Issue number 2, my lord, is this, the issue of bias. And this is bias by the honorable...
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that
Yes.
does not have to do with those prayers. My lord, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters, one of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see it, why I say this is important, is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So what, my lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my lord, I urge the court
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I said down, the issue of that right is that we have had a situation before the National Assembly, before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My lord, sir, just to add on what my learned friend has submitted on, I will give...
With the permission of the presiding, I wish to say I wish to make this clarification. The matters which are before us today, the 3 matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
Senator Council Mwete and Council Negua, you know, when you argue the way Mr. Mbe has argued, that court starts on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that courts start on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Murai. Let it not be an exchange between the court and yourself, because we are really very neutral party. Let us hear also from the other side.
We haven't really.
Your Lordship, we have not finished.
E015 in Kiruboya, the deputy president is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ugoya will be making submission. But my Lord, do give us this very weighty matter. This E015 in Kiruboya. The orders of your brother, Mr. Justice Mungo, were given at 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directions? Permit us to articulate these issues for the sake of the nation. We are not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
There is no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4. On the constitutionality of the constitution of this bench to hear these 3 specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number 2, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the root of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally,